world is changing. New technologies allow more people to work from home and less people to travel for business. Most business communication is now electronic. Electronic communication has made the workplace far more productive and efficient. However, the convenience of electronic communication has resulted in far greater legal risk for organizations and their employees. A single piece of electronic communication can travel to multiple offices and be seen by thousands of people, exponentially increasing the legal exposure for organizations. Managers can be sued and held liable or even terminated for participating in or failing to stop electronic harassment. This includes those actions committed outside the workplace and with personal devices. It's critical that managers and supervisors directly instruct all employees that their electronic behavior is subject to the same laws and organizational policies as their behavior in the office and in face-to-face communication. Offensive behavior is always unacceptable, regardless of the delivery method. If a remark is offensive in person, it's offensive when delivered electronically. Electronic harassment is the use of computers, cell phones, or other electronic devices to threaten, embarrass, intimidate, harass, or humiliate coworkers or other persons in the workplace. Hostile environment harassment occurs when a pattern of offensive conduct, regardless of methodology, unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. The federal government protects employees from harassment and discrimination based on race, color, national origin, religion, disability, family status including marital status and pregnancy, sex including sexual orientation, gender identity, and transgender status, age 40 and over, and genetic information. In addition, local laws and organizational policies prohibit the harassment of many other groups of employees. Any offense by a manager can result in the loss of their job regardless of if it was made in person or via email, text, instant messaging, or on a social media platform. When a manager uses electronic harassment to target or fails to prevent employees from targeting members of a protected group and creates a hostile work environment, it can become illegal. For example, a manager sends an email berating an employee for their age or religion or other protected class. Or a manager fails to stop or take action when this type of behavior is perpetrated by a coworker. A manager may be personally liable even if they're not the harasser. Failing to stop unwanted advances, sexual innuendo, or reputation-damaging contact made between any employees makes them culpable. For example, an employee complains to their manager that they've been sent a sexually explicit photo from a coworker and the manager does not take action. The company and the manager can both be liable. Managers must also intervene when the hostile environment is created by customers, contractors, and suppliers. It's also illegal to harass coworkers because they're perceived to be members of a protected group, even if they aren't actually members of that group. For instance, it's illegal to harass a coworker for being Jewish even if she isn't actually Jewish. Additionally, it's illegal to harass employees because of their association with members of a protected group. For instance, it's illegal to harass an employee because of his wife's nationality. Electronic harassment can occur between peers or between a manager and a subordinate employee. The law covers harassment between employees and non-employees, such as unpaid interns or independent contractors. Additionally, harassment can be perpetrated by third parties like vendors and customers. Harassment can occur anywhere that employees represent their organizations. This could be in a hotel room, at a trade show, on a sales call, or even at home from a personal device. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The law only looks at the perception of the victim. The perpetrator's intent is irrelevant in court. Quid pro quo harassment occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. Quid pro quo harassment often occurs electronically. For instance, a manager cannot withhold or award job benefits in an effort to force employees to send inappropriate pictures or engage in sexting. Additionally, managers may not make employees endure harassment as a condition of employment. For instance, a manager cannot tell salespeople that they'll have to put up with degrading jokes and pictures sent to them electronically because this behavior is commonplace in sales departments. Just one incidence of quid pro quo harassment is illegal. The following examples of inappropriate behavior could result in a claim of hostile environment or quid pro quo harassment. Sending harassing messages via social media platforms such as Twitter, Facebook, and Instagram. Posting pictures, videos, or messages that depict coworkers negatively. Cyberstalking by obsessively following a coworker on their social media networks and blogs. Sending harassing, intimidating, sexually explicit, or inappropriate text messages or photos by text, email, or instant messaging. Requesting sexual favors in exchange for a job benefit, such as a promotion or more favorable work assignment. Sharing secrets about victims with other employees, such as their search for another job or their sexuality. Damaging a coworker's computer by sending viruses by email. Encouraging others to harass a victim by falsely claiming the person has harmed them or their family. Threatening to release harmful information about victims to blackmail them. Impersonating coworkers, business associates, managers, or company executives to post or send inflammatory comments. Posing as the target to express interest in sex on dating sites, social media, or through electronic communications. Harassing a coworker during a live chat, conference call, or video meeting. Sending or posting hateful speech that attacks a specific aspect of the target's identity, such as race, ethnicity, religion, or gender identity. Message bombing or intentionally flooding phone or email accounts to limit or block access to a coworker's devices. Sending or posting private sexually explicit images or videos of coworkers or business associates. Damaging a coworker's reputation by posting false information online, such as fictitious criminal records or lies about sexually transmitted diseases. To avoid these situations and protect the organization and themselves, managers should instruct employees to never send racy photos, emails, or texts to coworkers, even if those coworkers are friends or romantic partners. Think carefully before posting on social media. Only comments, photos, or messages that do not violate company policies are acceptable. Even posts on personal accounts from personal devices could be seen by coworkers or business associates. Keep all devices secured. Use strong random passwords that are protected and locked when not in use. This applies whether working in the office, off-site, or at home. Make sure that all communication sent via text, email, or instant messaging does not violate company policy or break local, state, or federal laws. Promptly notify managers or supervisors about inappropriate behavior by following organizational reporting procedures. To prevent electronic harassment, managers must take the following actions. Put in place use of technology and anti-discrimination policies to prohibit electronic harassment. Thoroughly investigate allegations of electronic harassment. Document all harassment incidents. Because this type of harassment creates an e-trail, documentation can provide tone, frequency, and severity in the form of a permanent record. Warn employees that there is no expectation of privacy on company devices, whether the communication initiates at work or at home. Stress to employees that electronic harassment based on race, color, gender, or national origin creates a hostile work environment and is illegal regardless of the method. Inform employees that the courts have found that online platforms are an extension of the workplace. Create an environment where employees feel comfortable reporting all instances of harassment and stress that retaliation, either as a witness or victim, will not be tolerated. Establish a clear complaint and discipline process. Make sure employees understand the procedure for reporting electronic harassment. Periodically review social media policies to ensure they meet current legal standards. Notify the social media platform, email provider, internet company, or phone provider if the harassment is criminal. Establish a clearly defined policy for the actions managers must take when they receive a harassment complaint. Ensure the electronic harassment policies comply with Title VII of the Civil Rights Act. Implement social media policies that address all forms of electronic communication and educate employees on the scope of their responsibilities. Prepare and keep up to date a complaint resolution procedure for receiving and resolving harassment complaints. Make sure the company's anti-harassment policies specifically address electronic harassment. The complaint process should provide multiple ways to report harassment. Implement a training program so employees know how to follow the complaint process. Every complaint should be dealt with immediately, seriously, and consistently. Listen respectfully and without assumption. Don't minimize their complaint. Assure the victim of confidentiality. Remove the victim from any current or potential jeopardy. Inform HR and employer immediately. Document each step and the facts of the complaint without opinion. Remain unbiased and neutral. Investigate the complaint by reviewing emails, texts, or an employee's online comments about a coworker or supervisor. During the investigation, suspend or reassign the employee that was accused rather than the claimant to avoid a discrimination claim. Communicate to the accused that this measure is only until the investigation's outcome and does not reflect guilt. Investigate to make sure other employees are not being harassed. Notify authorities in cases of non-consensual pornography. Legal intervention may be required as 41 states currently have laws and protocol regarding this specific behavior. Report all company actions to resolve the complaint to the affected parties. Provide support services to help manage the stress of employees that have been victims. Electronic harassment, especially non-consensual pornography, can be very traumatic. To avoid future claims, mandate employees reread the company anti-harassment policy annually. Additionally, require training for managers on how to handle harassment claims. It's illegal to retaliate against someone for making or participating in a harassment complaint. This means that managers cannot punish or discipline employees for filing or participating in a harassment complaint. For example, a manager cannot reduce an employee's pay or responsibilities. Even if the complaint is found to be without merit, the participants are protected if they had a good faith belief that harassment occurred. Electronic harassment and retaliation can result in disciplinary actions including written warnings, suspension, demotion, and termination. Electronic harassment can result in fines and judgments from the EEOC and millions of dollars in civil judgments. Some types of electronic harassment may violate criminal law, such as pornography or cyberstalking. Employees who violate the law could face restraining orders and even prison time. Electronic harassment causes decreased productivity, employee turnover, absences, and elevated medical costs due to added stress at work. Harassment charges often affect future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. Electronic harassment is a serious concern for employers. It's essential for companies to protect their employees and avoid costly and embarrassing litigation by taking proactive steps to prevent such abuse. Managers must provide a safe, comfortable environment at work, a workplace free of harassment and fear and full of respect. It's up to everyone to do their part in preventing harassment to create a more positive and productive workplace.